May it please the court.
Go ahead.
Today, this very day, is the 10th anniversary of what has been referred to as Albuquerque's worst day. 10 years ago today, a mentally ill man named John Hyde went on a rampage in this city and killed 5 people, including 2 Albuquerque police officers, Michael King and Richard Smith. Officer King and Smith were doing their job in confronting Mr. Hyde, and he killed them. 10 years ago today, we were reminded of, while unfortunate, how dangerous the mentally ill can be and how dangerous a police officer's job is when dealing with the mentally ill. This case today reminds us of those sobering facts. 2 weeks ago, when I made my opening statements, I mentioned that despite what the prosecutors want you to believe, this is not a civil case against the Albuquerque Police Department. The caption on the criminal information does not read State of New Mexico versus the City of Albuquerque. It reads the State of New Mexico versus Keith Sandy, the State of New Mexico versus Don Perez. These are 2 police officers who the government want to charge for murder for doing their job. And when I say doing their job, I mean doing their job. When Keith Sandy made the split-second decision to shoot Mr. Boyd, he was obligated to shoot him. He was obligated to shoot him. You heard Officer Hubbard tell you that in that specific scenario, Keith Sandy was obligated to protect his fellow officer. But the government says that despite that obligation, Keith should be held over for murder charges. I would also remind you of the expert witness who testified named Ronald McCarthy. He had decades of training and experience in the use of force with the Los Angeles Police Department. I asked him this question: can you sum up his whole responsibility, meaning Keith Sandy, right immediately prior to the shooting of Mr. Boyd? His answer was, his total responsibility at that point in time is the protection of officers that he is sworn to protect and has been trained to protect. Your Honor, the protection of officers that he is sworn to protect. I asked him then the following question: would a reasonably trained and experienced officer perceive a deadly threat based on what is presented in Officer Perez's helmet cam video based on training and experience? His answer, Your Honor, yes, sir. You also heard yesterday Officer Weimerskirts testify that Keith Sandy and Dominic Perez saved his life. If Keith Sandy and Dominic Perez had not acted in that moment and done what they were sworn to do, done what they were obligated to do, they wouldn't be sitting here. But they may be attending a fellow officer's funeral, just like so many officers did 10 years ago this week. There is no doubt that Mr. Boyd's death is a tragedy. The reasons for his death and the way we as a society deal with the mentally ill should be discussed and dealt with. But that discussion belongs in a different venue and certainly not in a criminal proceeding charging these 2 officers. Your Honor, as you know, our community is watching this case closely and rightfully so. The citizens of Albuquerque want to believe that the police department operates properly and appropriately. And part of that means that they want their police officers to be able to protect their fellow officers from harm and death. No one can legitimately argue against that premise. But if this matter is allowed to go forward on these charges, it will have a terrible and chilling effect on police officers throughout this city.
Your Honor, I'm going to object. I think that's an improper argument in court to ask you to make your decision based not on the evidence, but on how it will affect the community.
This is argument, Your Honor.
Counsel, I can sift argument from the evidence. I will do that. Go ahead.
if this matter is allowed to go forward on these charges, it will have a terrible and chilling effect on police officers throughout the city. It would be saying, regardless of your training, regardless of your experience, regardless of the deadly threat that is posed, don't shoot. Don't shoot regardless of who may die. And we know this will happen. We know this chilling effect will happen. We need to look no further than this last weekend in Birmingham, Alabama. A police detective, it's been reported, who was pistol whipped, he was pistol whipped unconscious, said that the reason he didn't use force was because he didn't want to be accused of needlessly killing a man. Our police officers are forced to make split-second decisions based on their training and experience. And that is exactly what we want them basing their decisions on: training and experience. As a threshold matter, this is not a case of self-defense. Your Honor, if you follow the government's logical conclusion that they're arguing this is a case of self-defense, then they're arguing that Mr. Boyd would be justified in stabbing the police officer. The state argues self-defense, and that completely misses the point that these two people are police officers. The body of law that applies in this case starts with NMSA 30-2-6. That the only body of law that applies to this case is justifiable homicide by a police officer. NMSA 30-2-6 authorizes a police officer to use deadly force where the officer has probable cause to believe he or another is threatened with serious harm or deadly force while performing his lawful duties. The principle is captured in our jury instruction 1451-73, and is further defined and developed by the 2002 Court of Appeals case of State v. Mentelli at 131 New Mexico 692. Your Honor, in Mentelli, the court pointed out that police officers have a different standard than a regular citizen when dealing with a threat. The citizen is judged by a reasonable person standard. And that makes sense because that jogger up on the side of the mountain, if he shows up in front of someone with two knives, he gets to turn around and run away from that threat. Police officers are not allowed to simply run away from every threat. In fact, they are required to protect the public and are therefore required to confront the danger head on. Mentelli specifically stated a police officer may be legally justified in using deadly force in a variety of situations that would not apply to self-defense and the ordinary citizen. Mentelli goes on to say that police may have a lawful duty to be the aggressor. A lawful duty to be the aggressor in fulfilling their responsibilities to the public. Finally, Mentelli goes on further. It says, an officer might be justified in using deadly force to prevent a dangerous felon from evading capture and threatening serious harm to others. The police officer shoulders that responsibility as part of his duty to protect the public. This is not a case where ordinary self-defense is applicable in any way. The standard in this case is whether Mr. Sandy had probable cause to believe that Officer Weimerskirch was threatened with serious harm when Mr. Boyd, a mentally unstable man who had continuously threatened to kill officers with knives, drew those knives and made a sudden movement toward Officer Weimerskirch. Two final points on the law in this case, Your Honor. For there to be probable cause, Mentelli dictates that the facts must be such as would warrant a belief by a reasonable officer based upon the expertise and experience of the officer, and that the burden is on the state that the killing was not justifiable. I realize we're not at the beyond reasonable doubt stage, Your Honor, but they have to show some shred of evidence that it fell below the reasonable officer standard as laid out in Mentelli. So just to be clear, the standard for these officers that they must be judged upon is that of a reasonable officer based upon the expertise and experience of the officer. So knowing that that's the state's burden to prove that the killing was not justifiable, as Mentelli says it is, what evidence did the state provide this court to meet its burden? None. Zero. They provide you with no evidence. They provided you with no evidence, no testimony, from no type of evidence of any sort, that Keith Sandy or Dominic Perez fell below what a reasonable officer, based upon his expertise and experience, would do in this incident. They provided you with nothing. To the contrary, Your Honor, officer after officer after officer, including some of the state's officer witnesses, testified that based on their training, their experience, their expertise, they would do the same thing that these two officers did. An expert witness of use of force described for you the deadly threat. An expert described. That is the evidence before you. Mr. McCarthy testified as following, and I'm reading from the transcript of his testimony in court. This is me asking a question. So my question is, based on the training of a reasonable officer and the expertise of a reasonable officer, if I was standing right there with my hands like this to you, is that a deadly threat, sir? Answer, without a doubt, sir, it is a deadly threat. Question, and are officers trained and told that this type of situation, this proximity between the subject and the officer, that this is a deadly threat when someone is holding two knives pointing at them? Answer, holding one knife would be considered a deadly threat, yes. Question, and in this proximity with the two knives, is an officer trained to treat this deadly threat the same as if he had a gun in his hand right here? Yes, sir, was his answer. Question, there is no difference in what the officer's perception should be based on training of him standing here with a knife or him standing right here about a gun. Is that correct? Answer, he is a deadly threat, and the distance is what now equates that. At this distance, there's no question that he can close the distance before I can respond and hit me with the knife. Question, and therefore these knives, officers are trained to consider these knives in the subject's hands at this proximity the same way they would treat a gun. Isn't that correct? Answer, yes. Question, you mentioned something earlier about reaction time. Do you remember that testimony? And this is Mr. McCarthy. Answer, yes. Question, are officers trained that they cannot respond with a reaction the exact same time as the action opposing them? Do you understand what I mean by this? Answer, yes. Question, is there a range? In other words, you said 3/4. Is there any type of range, or is it to react? Is it going to take you 3/4 of a second? I think you said that, but that can't be the same for every single police officer, right? Answer, no, it's not. And it's taught that 3/4 of a second is a really fast response, and it's very often it takes longer than that. Question, are they trained? And are they trained it takes longer than that because they have to perceive it, it has to hit their brain, and they have to do something with their body to react it? Is that why? Answer, that's the training, yes sir. And it's discussed how that works. Observation, perception, orientation, action, and now realize that everyone may change and get worse, so you're going to have to repeat the observation, orientation, decision, action. Your Honor, here's a question I asked. Are officers trained that when Mr. Boyd was standing there, this based on your review, are they trained in the very exact similar situation that they are allowed to use lethal force on Mr. Boyd? The answer, yes, sir. Question, Mr. Sandy's job at that time was lethal cover. Would you agree that's what your understanding of the incident was? Yes, sir. It's called deadly force cover or lethal cover. Either term is utilized. Question, and really, can you sum up what his sole responsibility is right immediately prior to the shooting of Mr. Boyd? What his responsibility is? His total responsibility at that point in time is the protection of the officers that he's sworn to protect and been trained to protect. Would a reasonably trained and experienced police officer perceive a deadly threat based on what is presented in Officer Perez's helmet cam video, based on training and experience? Answer, yes, sir. Now let's talk about the state's evidence that they presented to counter that. There is none. The state didn't present any testimony, any evidence to counter what I just read and what is the sworn testimony before you. They didn't present any evidence all the officers that testified. And by the way, this is a good time to mention this. It is only argument because there's been no evidence whatsoever. But the prosecution, Your Honor, is basically saying that every one of these police officers, when they told you that's what we're trained to do, is lying because of this thin blue line. They are willing to take the step and make the argument that these police officers who are sworn to uphold the constitutional law would come in here, take an oath to tell the truth, and every single one of them would lie. That's their argument because that's all they have. It's a case where they have no evidence whatsoever, so they say it's a thin blue line. They are calling every single police officer a liar that took that stand and said they followed their training and experience. And I think that's unacceptable, Your Honor. There is a lot of argument on the part of the state. There's a lot of red herrings, but there's no evidence. For example, based on the state's questions that they've asked officers, based on their opening and based on the closing I just heard, they mainly argue the following points. The police had more people there than just single Mr. Boyd. Well, when someone brings out knives in the open space, the police respond with a lot of police officers because their job is to protect the public. That's the way they're trained. The state argued that the police have lots of guns and bullets. Well, that's what police officers carry when dealing with a delusional and violent man who is threatening to kill them with knives. That's how they're trained. And the idea that I just heard in closing, that somehow only 7 officers have died at the hands of a knife, and somehow that's acceptable. Out of 570 some officers that have died in the line of duty, only 7 have died by knife. Well, thank God Officer Weimer-Skirts wasn't one of them. The state argued that police have waited, they should have waited longer before trying to take Mr. Boyd into custody. How much longer should they wait? Should they wait till it's completely dark to make this already tense situation even more dangerous and unpredictable? The state argues that Mr. Boyd was surrendering. By the way, no evidence of any of these things, but the state argues it. The state argues that Mr. Boyd was surrendering, refusing to give up your knives, Your Honor, refusing to go get on the ground after being yelled at multiple times to get on the ground, with cops all around you, pointing guns at you, and then pulling out your knives from your pockets. That cannot be considered surrendering. Non-lethal force didn't work. They're going to argue that. We can all agree that non-lethal force didn't work, but the point is they tried. They tried. And not everything in police work is perfect. It did not have the desired outcome. While tragic that the non-lethal did not work, was not executed perfectly, does not make these 2 officers murderers. The dog handler closed ground and was too close, and that was a mistake. The dog handler admitted that yesterday. Officer Weimer-Skirts says yes, and looking at this, I didn't realize it, but I was way too close. So knowing that, what's Officer Sandy supposed to do? If he knew that he was too close, what's he supposed to do? Just let him get attacked? Say, sorry, you messed up, you got too close, I can't protect you anymore. Let's even say that he was negligent in getting too close, the dog handler. What's he supposed to do? Sorry, Skirts, you're going to get attacked. You might even die. I'm going to sit here and watch it happen. What's he supposed to do in that split second? And that's the biggest point of all, Your Honor. There is no doubt that the law requires them under Mantelli to show what a reasonable officer would do in the same circumstances. They have not given you one shred of evidence on what a reasonable officer should have done instead of shooting Mr. Boyd. They haven't even told you. What is it that Keith Sandy and Don Perez are supposed to do? Sit there and let him die? That can't be the answer. At that split-second decision, when they see the lethal threat posed to the officer, they have to do something. And their job, and their only job, as witness after witness has testified, is lethal cover. That is their job. That's the only thing Keith can do, is to stop that threat. That's all he can do. And that's the point. all those things that the government argues, how much they want to make out of the fact of whether or not the open space officers handled this correctly or not. None of that matters for your analysis. None of that matters for your analysis. This is not a civil case against the Albuquerque Police Department. Your analysis is the following. Would a reasonable officer, based on expertise and experience, take the same action Mr. Sandy did when he shot Mr. Boyd? There were 4 Albuquerque police officers in close proximity to Mr. Boyd when he was shot. 4 of them. Officer Weimerskirts, Sergeant Ingram, Detective Sandy, and Officer Perez. Every one of these officers perceived the same deadly threat when Mr. Boyd pulled out the knives 8 to 9 feet away and over 3.5 feet higher than they were. Every one of these officers has been trained in the use of force and has had years of experience. Every one of these officers, because of their training and expertise, every single one of them would have shot Mr. Boyd because they understand their training, they understand their obligation, and they understand their sworn duty. The evidence before you is now not just a video, Your Honor. It's not just a video that's been laid out in the public for months, but context now has been given to it. Context has been given to you in the form of sworn testimony from officers who were at the scene. The undisputed facts are as follows. When open space officers made contact with Mr. Boyd, he pulled out knives on them, committing the felony of aggravated assault with a deadly weapon. Officers over a 3-hour period repeatedly asked him to disarm himself and put the knives down. Mr. Boyd, on numerous occasions during this time, threatened to kill various officers. Mr. Boyd, on numerous occasions, pulled out the knives out of his pockets and threatened to kill officers. Officers on the scene learned that Mr. Boyd had a violent past, including battery on a police officer. An Albuquerque police officer trained in crisis intervention negotiated with Mr. Boyd, to no avail. The state police were called out to negotiate based on Mr. Boyd's request, to no avail. Officer Weimerskirts developed a layered approach using non-lethal force. It was getting dark, and lighting in the area was becoming a problem. Officer Weimerskirts decided to use a plan of non-lethal force. The flashbang device did not have the desired outcome. The taser shotgun did not have the desired outcome. The police dog did not have the desired outcome. Keith Sandy's sole responsibility was lethal cover to protect Officer Weimerskirts. Dominic Perez's sole responsibility was lethal cover to protect Officer Weimerskirts. While Officer Weimerskirt advanced to take Mr. Boyd into custody, Mr. Boyd was ordered by officers to get on the ground 4 times. Instead of getting on the ground, Mr. Boyd reached into both of his pockets and pulled out 2 knives with 4-inch blades. When Mr. Boyd pulled out the knives, and he was 8 to 9 feet away and 3 feet higher than the officers. Police officers are trained that knives are deadly weapons and when in close proximity should be treated the same as if they are guns. Mr. Boyd, with knives in his hands, did take an aggressive step towards the officers. Officers are trained that if a person with 2 knives 8 to 9 feet away threatens a police officer, it is their duty and obligation to shoot that person. So, Judge, I ask this question. How can the state prosecute a police officer for murder when the police officer was following the training that the state provided him? If an officer is following his training, he cannot possess the criminal intent for murder. Finally, I've heard Ms. McGinn imply through a question that these officers were cowards. She asked the question of a witness, have you heard the saying in the Old West that cowards shoot someone in the back? I think that is a sad mentality towards 2 police officers, Your Honor, who have combined have given over 25 years of service to this city. Regardless, I want to address the basic argument that she is trying to make through that question, and that is specifically Mr. Boyd's wounds and the angle of the entry wounds, and therefore somehow it was murder. The government spent some time attacking Mr. Lewinsky in his testimony, and although I think it's misplaced based on the testimony that he gave, he demonstrated something to us that we all know in common sense, and he makes us think about it, I think. It's the following, Your Honor. Police officers are required to react. React to what a person or a subject does. And that takes time. It takes time to perceive the threat. It takes time for your brain to analyze what it perceives. It takes time for the brain to tell the body what to do, and it takes time for the body to do what the brain told it to do. And what I think this clearly points out when they're making this argument is the government really arguing that if they'd shot him a second earlier and all the bullets would have gone through the front of the body, then it would have been justified? That if they were just quicker with their trigger, if somehow their brain had worked faster, then it wouldn't have been murder. They can't seriously be arguing that. That brings me back, Your Honor, to the law. And I'm quoting now. You've heard this before in this last 2 weeks. The reasonableness of a particular use of force must be judged from the perspective of a reasonable officer on the scene, rather than with 20/20 vision of hindsight. The calculus of reasonableness must allow for the fact that police officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving. And as this court knows, that's the United States Supreme Court in Graham v. Connor. That case, as Mantelli points out, was the case, when that case was decided, our New Mexico legislature enacted 30-2-6 based on that case by the United States Supreme Court. For you to hold over these two officers, Your Honor, I think what you would be required to do is to completely disregard all of the testimony and evidence supported that they acted reasonable based on their training, and then rely completely on the evidence that the state gave you on whether or not they met a reasonable standard and what a police officer should have done instead of what they did, which is none. That's what would be required for you to hold them over, Your Honor. Now, we can all play the video of this incident in our minds because we've seen it now so many times. And I want you to imagine the following. That as they begin their layered approach, they throw the flashbang. It doesn't work. They're using the taser shotgun. It doesn't work. They let the dog loose. It doesn't work. And you can visualize seeing Mr. Boyd putting his hands in his pockets, and he reaches in, and instead of pulling out knives, he pulls out two guns. We wouldn't even be here today if that's what that video showed. But here's the important part of that, Your Honor. We know we wouldn't be here if he pulled out two guns. But these officers are trained to treat those two scenarios the exact same based on the distance. And if they want to say that Officer Weinerskirt's closed the ground too quickly and it's the Albuquerque Police Department's fault, that is for a different courtroom on the civil side. It's not his fault. His duty is to follow right behind him the whole time. It's not his fault that Weinerskirt's, if he made a mistake, he made a mistake. That's not his fault. He simply cannot let him there to die or to be seriously stabbed. Your Honor, while Mr. Boyd's death is tragic, as is all death, it was justifiable homicide by police officers. I ask that you dismiss the information against Mr. Sandy.